Hey guys, I just wanted to jump on really quick and talk about this bold letter put out by Wayfarer today. I just spent a long time answering some questions in the comments for the different videos and also on the community tab. You guys had some great questions. And then I was preparing the episode about this motion to dismiss filed by Jonesworks. But this letter is so bold. And since it's just a short one-page letter, I wanted to just jump on and cover it before I got the other one finished. So this was written by Kevin Fritz. He's another attorney that's counsel for Wayfarer, Justin, Jamie, Steve, collectively the Wayfarer parties. He says, "We write to notify the court that the Wayfarer parties do not intend to move for leave to amend their pleading by the April 18th, 2025 deadline set forth in the case management plan and scheduling order. The Wayfarer parties stand behind the operative first amended complaint and are confident that, for the reasons outlined in their opposition briefs, the currently pending motions to dismiss will be denied." So they're like, we stand by what we said. We don't think that your motions to dismiss refuted what we said. We don't need to say it again. Then they add, if the court were to grant one or more of the motions to any extent, that then they will move for leave to amend. That shows a lot of confidence. It makes me wonder just what they've found in discovery. And it's also a smart move because at this point they probably don't have everything that they need to discover yet, and they can continue to find new information should they need to amend after the court makes its decision. I also love that they didn't file motions to dismiss themselves. As I've said multiple times, they're almost never granted, and all they do is reveal to the opposing party what your strategy at trial is going to be. So by not filing those and not moving to amend, really they're giving nothing away. And I had another sneaky suspicion. Now, this is just my own thoughts about their request to extend the deadline, both for amending the pleading and then changing the scheduling order. I was thinking to myself, there's no way these attorneys are not prepared. So what might be another reason that they do this? That they put this out for Team Blake to snap back and do their best to try to humiliate them for it and ridicule them for it and mock them for it, saying, oh, you're not ready, you don't know how to handle your calendar. I'm like, why would they put themselves out there like that, to be mocked in such a way? And I couldn't help but wonder if perhaps it might have been to hurry the court along a little bit to make their decisions on these motions to dismiss, just by bringing awareness to the court about how close they were to these next steps. And they still haven't received a ruling on one of these motions to dismiss. Today's the 15th already. With these amended pleadings being due on the 18th, they kind of need the information that would be determined if any of these motions to dismiss are granted. There will be information in the court's decision to let them know what amendments need to be made. So I couldn't help but wonder if it might have been just kind of a little nudge saying, hey, let's get these decisions made. But that just might be me attributing my impatience to their motives, because I'm just getting tired of waiting for the court to decide what to do about these motions to dismiss. As I've said before so many times, I don't believe any of them, no matter how confidently they spoke, stood the slightest chance at having these granted, except for the New York Times in the very beginning. But I think it says a lot that when the judge at the hearing quite a while ago granted their motion to stay discovery because he said he was feeling inclined to granting their motion to dismiss, and yet has not granted that in all of this time. So it makes me all the more hopeful that he's reconsidering granting that, and that some of these issues that have come up since then, like this subpoena, and we talked about that long before it became such a hot topic, about where the subpoena could have come from, and based on what, and if there's something wrong with it, will it still give New York Times the protection that they're expecting to be covered by? So I'm really hoping that the delay in the New York Times case, at least, might mean he's changing his mind, or at least considering changing his mind on that. But anyway, I loved the confidence in this letter. I love that they're not giving away their strategies. I love that they feel their causes of action are in line with law. And that makes me believe that what they're finding in discovery is really, really good. And I really look forward to hearing it at trial, because I think we're going to end up having to wait till trial to hear all the juicy stuff. And now back to this awful Jonesworks motion to dismiss. I'm so tired of these motions to dismiss. And if there's no amended pleading, we won't have to hear about these again. But I'll be back soon with more information. Till then, this is Cassidy O'Connell saying stay well and stay tuned.